and weird streaming.
All right, the Court of Appeals, First Appellate District of Ohio, with the Honorable Marilyn Hyatt presiding. Please be seated.
Good morning.
Good morning.
I hope everyone had a great weekend. Hopefully not too fast of one. Alrighty. So I recognize that there's a lot of parties in this case and there's a lot to be argued, including jurisdictional matters. So we've allotted 20 minutes to each side. And I know that you have confidence and determined how you will be allocating that time. So if you can share that with the court.
Good morning, Your Honor. Ernestine, on behalf of JFS, on our side, we have 5 for me, 3 reserved for rebuttal. Ms. Bench has 5. Ms. Eves has 3.
Okay, hold on. I write slower than you speak. Okay, so you have 5 and then 3 for rebuttal. Okay.
Ms. Bench has 5.
Okay.
Ms. Eves has 3. Tony has 3. Ms. Thomas has 1.
Ms. Eves has 3.
Yes, Your Honor.
And then,
Mr. Meyer for Applebee's.
okay.
Has 3. Ms. Thomas has 1 minute from our side. And hopefully that adds up to 20.
Okay. Thank you.
Your Honor, Sarah Michael, attorney for the parents, John Catherine Snyder. I am going to take 10 minutes with 2.5 minutes for rebuttal. And Ms. Thomas is going to use 5 minutes of my time and 2.5 minutes for rebuttal.
All righty, thank you. All right, so I'm going to pull out the docket now. So we have 3 cases on the docket this morning. 2 will be arguing. One has submitted on the briefs. The first is case number C210672, 680, 22005, 006, 193, 202, which is in re as children. The next we have is case number C210442, 443, 444, State of Ohio versus Klosterman. On that case, if you can please identify yourself and your readiness to proceed.
Laura Peters for John Klosterman, ready to proceed.
Attorney Susan Zerfis for the State of Ohio, City of Cincinnati, prepared to proceed.
Thank you. And the last case we have is State of Ohio versus Harris, case number C210661, which has submitted on the briefs. So we're going to start with in re as children, okay? And
I'll get the show rolling.
yes, I figured since you shared with us the allotment of time.
But I'm tired. It was a long weekend. It's back from vacation, and I got to ride back from Lake Erie with all the kids. My wife said, no, you take them. I'm not riding back for them. So there's where we are. So, but Judge Zayas.
Hopefully you had some coffee this morning.
Yes.
Maybe
yes.
one of those. I'm hearing that some people are doing 4-shot Americanos, so maybe you had one of those.
I just went with the freshest Coke just to get the day rolling, but we're good. But it's good to see you, Judge Bergeron, Judge Winkler again. As I was going through this, our issue on direct appeal is the one that we brought before this court twice before, is the reluctance on the part of the trial court to address the death of A.S. That was the court even puts in its entry, that was a pivotal moment in this case. That's what triggered it.
Mr. Lee, before you get into this, I'm a little confused on what the state's or what JFS's position is here, because there has been a dependency finding and there has been a finding of custody with the say words. Are you, and I'm confused by your position, are you saying the dismissal of JFS's claim was improper and custody should come back to JFS?
No. See, Your Honor, that's the oddity of where we're at here. We're kind of having to say, globally, the court was right. There was a lot of stuff going on in this household, and the dependency finding was correct with that. Our issue is the court's application of.
Yeah, no, I understand that part of it,
Sure.
but my problem with that is typically we don't allow a party who's won effectively below to then come back and say we should have won in a more robust manner, or we should have won these issues that we didn't win, if at the end of the day the net result is in your favor.
Well, the issue here, Your Honor, is frankly it goes to the third appeal, the visitation component. Let me back you up. I'll go back about 18 years. There was a mother on a case that I had about 18 years ago.
So what you're saying is what you're arguing does change the outcome.
Actually, when you look at what Ms. Eves will argue, it could potentially change the outcome, but it also affects the long-term legal custody disposition. If this was a permanent custody finding, which is what the complaint was, we would not be appealing this underlying issue. But this is a legal custody finding, meaning the court retains jurisdiction over these children at any time up till the age of 18. CS2 is now 6 years old. There's now 12 years of litigation. The underlying seminal moment in this case was the death of AS. Absent finding on that issue, no court in the future can determine the suitability of the Snyders if something happens to the Sayward. We're all aware that it's not a change in the parents or adoptive parents, but it is if something happens to the Saywards, say they are not able to care for these children.
So wasn't there a dependency determination with regard to the other children?
No, I don't believe it does, Your Honor, because when you look at what the court addresses in the dependency finding, it does not. I think that there are global issues with the children, but it doesn't go back to address the concerns more, I hate to use the word robustly, with the Snyders. I think that's the problem we've got with this. Also, we've got a problem with the court. When you look at this entry relating to AS, I'm not quite sure. I read the entry again this morning. One of three things happened. She said, who or what killed AS? Again, wrong standard. Because a perpetrator is not required in this instance. But when you look at the abuse statute, death or at variance with a history given, that was what was presented here. That is the legal standard. The second is the court said it declines. I'm not sure if it declines, if the trial court actually did decline, but when you look at what the court says, I dismiss all abuse and neglect to all the children except this. Well, that, if the court applied the proper standard, which we don't believe she did, then that decision is against the manifest weight of the evidence. So we've got three issues that's very unclear with this decision, but it affects the lives of these children going forward. This is not a true situation where, and frankly, personally, I think it should have been straightforward to permanent custody. The department asked for legal custody, hoping that this would settle down, as these cases sometimes do, but I don't think it will. That's why this is important.
And I realize you have limited time this morning, but can you address, at least briefly, the jurisdictional issue?
For the visitation or the KM issue?
The KM issue.
The KM issue is, Judge, again, KM came out, our second appeal where this court remanded a couple of months before that. It wasn't raised. We raised it in the trial court. We went through adjudication, and I don't want to beat a dead horse here because we outlined this all in our brief, and I don't know, y'all have got probably 400 plus pages of briefs on this. But it was raised. How many times more can we raise it? Then when it came back after the adjudication, they filed to dismiss for lack of a final order. Again, it wasn't raised. It was sent back for lack of a final order. The trial court raised it again prior to disposition, and it was not. I mean, this is clearly an issue of invited error as part of the appellate component, but more importantly, when you look at the history of this, where we had a juvenile court judge address the time waiver, a writ was filed in this court, the court applied the law as it existed at the time. There were 2 true amended complaints that were filed. Subsequent, the parents filed a motion to waive time, and the court granted that waiver. And we've been proceeding on that waiver from 2017 ever since.
I mean, you raised an interesting issue because ultimately it's ultimately seen as an issue of jurisdiction,
Yes, Your Honor.
right?
Yes.
So you're basically saying, okay, you can invite error as to jurisdiction, and even though the court doesn't have jurisdiction to act and is acting.
Well, is it, then we're getting into the, wade into our old friend void and voidable orders. Is it truly void? Is this self-executing? Does this go poof in the night on the 90th day if nobody says anything? That would make it void. But, and I know that we cited a 5th, I think it was a matter of GT from the 5th, from earlier this year that addressed this as this would be a voidable order. It is not. An avoidable order is effective until it is either appealed or a 60B motion down the road, something of that nature right there. So if it's a voidable order, the court could proceed if nobody took any steps, which no one did in this matter until it goes forward. And again, I think it's not normally the process, but I would ask this court, what was JFS left to do? What other options did we do? We brought it to the attorneys. We brought it to the court. It was before this court. And now then, after we've had thousands of pages of transcripts.
Well, I mean, this is, but I mean, here you're pushing back on what the statute requires and what the Supreme Court has said. And I mean, we can argue the policy issues on that, but I mean, there is a bright line rule that the Supreme Court has implemented, whether we like it or not.
But the question is, Your Honor, is it self-affecting, self-executing?
Well,
It's not.
the Supreme Court says that there's no implied waiver.
But
And
there was an express waiver in this case.
where's the express waiver prior to the 90 days?
Prior to the 90 days, it was in 2017. The 4th amended complaint was filed, which frankly could stand alone because Judge Lips found that the time had run previously on the 2nd amended, and there was a captioning error on the
So you're
2nd.
saying it was waived before the 90 days?
Yes, Your Honor. It was well within the 90 days. And we do have that in our brief.
Okay.
So the parents actually asked for that waiver. So this is an express waiver that has nothing to do with implied at all.
Okay. Well, thank you. Good morning.
Morning, Your Honor.
And so you're arguing 5, right?
Yes, Your Honor.
Okay.
Thank you. May it please the court, I am Clarissa Benge. I am the attorney for the guardian ad litem, Amanda Lawson, in this case. Kind of along the lines of Mr. Elliott, you have read all sorts of briefs from us, and I'm sort of, is there something in particular you
I
would
want
like
to
to
ask,
hear about?
I want to start where we ended, which is, was it waived before the 90 days?
It was. There were a total, I believe, of 4 complaints. At one point, there was a duplicative complaint filed, and Judge Thomas Lips noted that in his entry when he ruled on it. After that,
Let me ask the question a little differently. Was it expressly waived before the 90 days?
yes, it was. Their motion, I believe, I don't have the exact dates in my head, it's in the brief, their motion, they filed a motion to waive time and for a continuance, and that was granted by the court, and that was before the 90-day expiration on that 4th amended complaint.
But what about but what started this off was like the First Amendment complaint. So was there an express waiver before the 90 days ran on that?
No, that's when we were in this court. That's when there was a motion filed in front of Judge Lips, and then a writ filed with this court between the first and second waiver.
So you're counting it from the amended complaint?
I'm going from the 4th amended complaint. The waiver was, and motion for continuance was filed before the 90th day ran on that.
Was
me
the-
ask you, I'm sorry, go ahead.
I was going to ask, was the amended complaint substantially different?
Yes, it added, it added at least 2 paragraphs of facts. The complaint prior to that added facts as well as changed the prayer from temporary custody to permanent custody. There was only one complaint that was a duplicate, and then I believe that was the second one. And then the third one had new facts and a new prayer for relief, and the fourth one had new, further facts added.
Let me ask you, concerning I believe it was a third amended complaint. I read that the parents filed objections, and one of the parents filed a motion to dismiss, and I believe that generated the fourth amended complaint that was filed the day before the 90 days expired. Is that true, ma'am?
There were so many complaint dates that I don't have all of those dates perfectly in my head. They are listed in the procedural posture of, I think, 2 different of my briefs. Yeah.
All right, but there were objections to the continuance as well as a motion to dismiss?
Early
The
on,
mother-
yes. I do not remember if there were on that third one or not.
Okay, 'cause my recollection, mother filed objections and father filed a motion to dismiss. It may be, okay.
You could very well be right, Your Honor. Again, those dates, that was 5 years ago now, and it's
Well, but I mean, these dates are pretty significant.
They are,
and,
but
and I mean, you all are saying there's waiver, but there were, to Judge Winkler's point, there were objections along the way. There was an effort to get this court to intervene along the way. So, as I'm understanding what you're saying there's a waiver that occurred by virtue of what happened with the Fourth Amendment complaint. Does that cure anything that happened earlier?
yes.
And,
Yes.
and why is that? What's your best support?
Well,
for
there
that?
is, so even though they're not self-executing, if those complaints expire and sort of go poof in the night, once a new one is filed, that restarts the 90-day clock. And so you have another full 90 days. It's new facts, new prayers for relief. It restarted the clock.
And what were the new facts in the fourth amended complaint?
The final 2 paragraphs.
Tell me what they were.
Tell you what they exactly were.
Well, but I mean, yeah, so can you just add a new paragraph each time and then you're like free of any sort of time constraint?
Well, I think it has to be done in good faith, Your Honor. I think you can't
Okay.
just
Well, so,
reiterate.
but if it's only 2 paragraphs, why is that so different that it would change the jurisdictional analysis?
Dependency complaints aren't typically incredibly long to begin with. And I think this one maybe added paragraphs 10 and 11 around there. But it was information that happened in that interim. Because you want to make sure if you're filing another complaint, right, that at that moment you file the complaint, you're not actually ready to send the kids home. If you were ready to send the kids home, you would perhaps file something different and you would actually send the children home if risk had been eliminated, if services or something had helped the parents to be in a better place that the kids could return home safely. That's the difference. You would not file another complaint for another 90 days if in fact, as a guardian ad litem, I wouldn't say it was in my children's best interest to sit in foster care at another 90-day complaint if there's no actual risk named in that complaint. But this was adding risk factors to that complaint. So all of the stuff that had existed before continued to exist. They added some more paragraphs. And because at that moment you have to add some paragraphs about the time, that it's either the risk still exists, something new has happened, something worse has happened. You have to show the court that risk to the children still exists.
Thank you.
Okay. Thank you, Your Honors.
Good morning, Your Honors.
Good morning,
Don't ask
Attorney
me about
Eves.
the time thing. That's not my job. I represent the children that were verbal at the time of the removal. I'd like the court to look at what Mr. Lee alluded to, that the court erred by not finding abuse of AS. I assert that the court erred by not finding abuse of
Let me ask you
MS.
about that. The court's confronted with the coroner, I believe Gretel Stevens, and also Dr. Maycroft, and then 2 independent doctors or MDs. And
There was Dr. Stat, Dr. Makaroff, and Dr. Stevens.
okay, and then 2 independents, and
Yes, if you'd call them.
so the court has to weigh the testimony. And if-
Absolutely, but the court did not use, the court failed, I put a witness on, Brenda Kennedy. The court had previously ruled that any evidence could come in that was prior to the fourth amended complaint. Ms. Kennedy took the stand. MS had acted out in extremely emotional behaviors, and there were statements by the mother to Ms. Kennedy. The court did not allow me to present that witness. Her full testimony is now in disposition. I made a very lengthy proffer. I was interrupted 3 times. The court had already ruled that Ms. Kennedy could not testify. There was never any really reason why, other than it was explosive, which it was. I believe the failure to allow Ms. Kennedy to testify at adjudication would have substantially affected the outcome, because it had motive, and not only was MS's Mayerson evaluation there, it was an extreme, demonstrative, emotional, excited utterance where Ms. Kennedy was actually knocked on the floor and the behavior was acted out again. NS kept interrupting, saying that's what happened, and named mother as the perpetrator of slamming AS to the floor, smearing feces in his face, holding him down.
So you're saying that would have been more persuasive to the court than the expert testimony on causation?
I don't think more, but I think it was extremely relevant and pertinent, and it was an eyewitness. It also affected MS's ability to be identified as an abused child. She has discussed and reported and acted out this behavior for 5.5 years, and it was demonstrative. You'll notice, I think, in the appellate briefs, they talk about her acting out in front of me, and I think their effort was to allude that somehow I triggered that, but it was not the first time it had happened. So I believe
So you're basically saying that the evidence would have gone towards abuse beyond the issue of whether there was homicide attached to AS?
Absolutely, and to MS viewing it, because she is completely traumatized.
Right. There's no self-homicide.
Right. So I think under Rule 103, I did a proper proffer. I also attempted to proffer or put that into my closing argument. That was denied. But the record was preserved. I did a very lengthy proffer because the judge came in 3 times and asked me, was I done? She did not hear it, and she had already ruled. Then Ms. Kennedy was able to testify. She's referenced in the disposition. It is almost exactly what my proffer was, which was, 3 years before. So I believe, though also the court did not do the permanent custody evaluation, which I think is pertinent and very important. My client's positions were still, other than CS1 at that time, who was, I think the judge mentioned, had some mental health issues and delays, and the guardian's position would take priority there, but that the children did not want to be with the Snyders. And I think the dispositional evidence clearly shows some of that why. You got questions?
Thank you.
I don't.
Thank you.
Good morning.
Good morning, Your Honors. Anthony Majorano for Applebee's Melissa and Lance Snyder. I want to use my time wisely, so if anybody has questions, please ask them for me. If not,
If you want to make whatever you think is the most important point.
So a couple things. One, on the first appeal, I assert that jurisdiction can be cured. There's
Depends on whether it's void or voidable.
well, there's a U.S. Supreme Court precedent stating that even if jurisdiction was void, as long as it's cured before the final judgment, that is, the judgment should stand. That's from Caterpillar that I cited in my Applee brief. The caveat to that is it must be invoked properly at the onset. So things like filing in the wrong court or lacking, in the Caterpillar case, if you lacked diversity jurisdiction at the onset, you could not cure it subsequent to filing. You would have to abandon that complaint and refile.
Diversity jurisdiction is wholly different than what we're talking about here.
I think it offers an analogous vehicle for you guys to evaluate what a jurisdictional cure could be. I do think that it's appropriate here. The Court of Appeals in 2017 ruled that the motion to dismiss was not, that was filed by one of the parents was not proper and it didn't need to be granted. Nonetheless, Hamilton County filed an amended complaint. It wouldn't make sense for them to dismiss and refile after that in that instance. And that's all I'm going to take on the first appeal. For the second appeal, which is, I know this is consolidated for, I think it's clear that my clients invoked the court's jurisdiction along with the guardian ad litem when the guardian ad litem filed the emergency motion and we joined that motion in regard to the visitation hearings that happened in April of this year. And I think it's also clear from the Denier case that the trial court has jurisdiction over the exact kind of motion that was filed where it modifies allocation of parental rights. In this case, that allocation would be unsupervised visitation. Although that deals with a slightly different court, it was from a domestic relations court. The civil rules and the juvenile rules state that they can't expand or contract this court's or the trial court's jurisdiction. So the rulings from the 12th district clearly state that jurisdiction is properly before the trial court to modify child custody issues. If you guys don't have anything else, I think that I'm...
Let me ask you, which 12th district case are you relying on?
Denier v. Carnes Denier.
Okay. Thanks.
Thank you.
Good morning, Your Honors.
Good morning.
May it please the Court, I'm Kimberly Thomas. I'm the attorney appointed to represent AS, CS2, and KS.
So is it 5 minutes that you're arguing?
I get one.
You get one?
I get one.
Okay,
But
one
on
total?
this side, no.
Oh, on that side,
that
okay.
side.
I missed that. Oh, here you are. You get a whole 1 minute. Okay.
So I'll
You
make it
might, you
again.
might win a record.
So, Your Honor, I do agree that the case should have been dismissed and refiled per KM. And as you had said in HMM, there is no flexibility in KM. You've heard, all the things that had happened prior. This court in HMM clearly said a juvenile court that forced the parties to continue litigating past the 90-day dispositional deadline exceeds its statutory authority. There's no law to support the position that if you file a new amended complaint after the 90 days, that cures that defect. KM was very clear. No dispositional hearing within 90 days. The only thing left for the court to do is to dismiss and refile.
So you're saying the amended complaint does not serve as the proper way to begin the
Correct.
process again?
Correct. And in line
Which
with
is what would be required under KM.
and under HMM. But I do believe that the court did retain jurisdiction to hear the petitions for legal custody, which were, that did not have to be dismissed. The first petition was filed days after the original complaint, and then the second petition was filed in which the Saywards actually won custody. So I believed, although the court did not have jurisdiction to proceed on the agency's complaint, they could have proceeded on the petitions, and they did. When they made their dispositional finding, they did not rely on the adjudication as an unsuitability finding, but did a whole separate suitability finding and found the parents unsuitable. Also to note that, and I must have looked at this 5 different times, the court mentions 2151.353, but never puts it on her entry that jurisdiction will continue under that statute, which is required by that statute. If you're going to have continuing jurisdiction, then you put it there. I think this will also speak to the second appeal, is if you just order this back to be dismissed, that there was no continuing jurisdiction, that 2151.353 no longer applied, that the court could exercise a jurisdiction on the petitions under 2151.23a. Thank you for your time.
Thank you. Good morning.
Good morning, Your Honors. Sarah Michael, attorney for the parents. May I please the court, there's been a lot of discussion here about timelines, and of course the timeline is the most important thing when we look at KM. So I just want to do kind of a brief overview of the dates, because I know that that's somewhat been scattered all over. The initial complaint in this case was filed on October 6th of 2016. There was a first amended complaint filed on October 20th of 2016 that had different facts. That is where the 90th day started. 90 days from October 20th of 2016 is January 18th of 2017. Here's why this is important. On November 17th of 2016, the agency filed a motion to continue this case. At that time, father objected to that continuance. The trial court granted the continuance anyway and set the hearing for January 27th, 2017 for the adjudication, which is past the 90th day. Additionally, they scheduled disposition for February 27th of 2017, which is also past the 90th day. In between there, on December 1st of 2016, mother filed a motion to set aside based on the case not being heard within the 90-day period that KM set forth. On December 19th, 2016, father filed the motion to dismiss, which Your Honor Winkler asked about, also stating that the complaint should be dismissed because it wasn't going to be heard before the January 18th, 2017 90-day time frame. And on January 19th of 2017, the parents filed a special writ in this court asking for the same to be done because the motion to set aside was not being decided timely in order to meet that timeline date. The motion to this court dismissed that writ, did not hear the merits of it, dismissed that writ, and additionally, the case then proceeded forward against the parents' will to try to stop it and stay within the timeline. The express waiver that they discussed here was made on April 3rd of 2017. This was well after the complaint should have been.
So it's your position that as long as the express waiver doesn't occur prior to the 90 days, even if subsequent to the 90 days, like the court in this case denies the motion to dismiss or grants a continuance, if subsequently the parents do waive, that's completely irrelevant in the jurisdictional analysis?
It is, Your Honor. In February of 2022, this court ruled in Re HMM that any express waiver made after the 90 days is void and the case must be dismissed and refiled. This is not a voidable issue. In Re HMM and JAM made this a voided issue. They stated that as soon as that 90 days hit, the court lost jurisdiction to even take a waiver after that. The case is dismissed and refiled at that point. Any subsequent amended complaints are not the same. An amended complaint is not the same as refiling a complaint in a dependency case. When you file a complaint in a dependency case, you have to then state that there is imminent risk again in order for removal. They're not the same. This court has ruled that in HMM, which the other side has failed to recognize. Additionally, just because NRA-KM was not on paper when this case started doesn't mean it existed. It didn't exist. NRA-KM, that's not a new law. That's been the law of the land forever. NRA-KM just established that courts have been perceiving the law and applying the law wrong. The 90-day provision has been in place. This is nothing new. It's not new in the statute. It's not new to the law. It just wasn't being applied correctly.
What about Ms. Thomas's point that you could, even if that's all accurate, that the court still could proceed on the legal custody petition?
So in regards to the legal custody petitions, the Saywards filed their legal custody petition well after the 90-day mark. Therefore, anything that happened after that 90-day mark is not relevant to this case. So their petition for custody is a non-relevant issue. The paternal grandparents did file a motion for custody several days after the complaint was filed. However, they were not actually made a party to this case until I believe somewhere in the 2020-2021 range. So when they filed their petition, they were not yet a party that could have proceeded forward. Therefore, on the 90th day, I believe their petition would have been dismissed also. Additionally, I don't think that it's fair to say that the legal custody petition would have gone forward if there was no dependency. So the legal custody petition was only allowed to go forward because there was a dispositional matter in the case. Had the adjudication not happened, or had the case been dismissed at the 90th day, there would have been no reason to have a motion for legal custody to move forward. Additionally, the grandparents who filed the legal custody motion were in support of the parents' custody being remanded to them, but had filed in the secondary in case the parents were unable to reunify. So I think that the picture here is that I think that HMM stated it well. The 90 days is a non-negotiable thing for this court. The case has to be dismissed at 90 days. This case should have been dismissed on January 18th of 2017. Now, it is true that the agency filed a second amended complaint on January 17th of 2017. However, that second amended complaint had no new facts. Judge Lips had substantiated this in his decision when he did the motion to set aside, that the complaints were absolutely identical from the first amended complaint to the second amended complaint, in which this court also ruled in HMM that if there is no change of facts and or change of substance, that amended complaint does not affect the 90-day requirement. Therefore, that second amended complaint filed on January 17th of 2017 does not cure any kind of jurisdictional defect that the court had. With the express
So
waiver,
if we were to agree with you, then what would happen with the children next?
If this court were to dismiss this case or do what we believe is statutorily correct, the case would be sent back to the trial court for dismissal. And at that point, the case could be refiled. The case could be filed in another jurisdiction. The case could be restarted. The fact that the 90-day timeline affects the dismissal doesn't give or cut off anybody's ability to refile and litigate this case. But the fact of the matter is, just because this case took an extensive period of time doesn't mean we get to overlook the jurisdictional statutes that the courts put in place to protect these kinds of things. Additionally, even if this court were to find that the parents made an express waiver somewhere down the road past the 90 days, the parents made an implied waiver prior to the 90 days because they had filed a continuance or an objection. They had filed a motion to set aside. They had filed a writ in this court. I'm not sure how many other methods the parents could have used to state that they were not in agreement with continuing it past the 90 days. The implied waiver is exactly what KM says you cannot do. if the express waiver were to be dictated and found to be plausible, I think that it would be argued that any express waiver made in this court by the parents was not knowingly or intelligently. The parents have been told on several occasions, they have been told by the trial court twice, they have been told by this court that they had no relief. So at that point, they are forced to proceed either way because they've already been told you have no relief, when in fact they did have relief, but this court found, or In re KM gave them that relief, but wasn't applied until later. Just because the case happened after that doesn't mean now the court can just say, sorry, we already told you no now, and we're not going to follow the law later.
Thank
I don't
you.
believe that's a proper procedure.
Thank you.
Thank you.
Attorney Thomas.
Kimberly Thomas again, and this is my 5 minutes.
This is your 5 minutes.
So there was an appeal filed in regards to a motion that the GAL had filed. Let me first back up and say how you rule on the first appeal is going to impact what happens on the second appeal, and I think that goes without saying. It could in whole or it could in part. But as it relates to what happened in April of 2022, the juvenile court, trial court, lacked jurisdiction to hear the GAL's motion on several areas, but we'll just go with the first. When the dispositional order was entered in December 1st of 2021, that concluded all matters. There were no matters pending. At that time, permanent custody was denied to the agency, and legal custody was granted to the Saywards. December 1st, 2021, the GAL was discharged per 2151281G, which says once their legal custody is granted, once all dispositional orders have been completed, and once a permanent custody matter has been dismissed, GAL is discharged. Now, everyone's arguing, the appellees are arguing, well, the court did not put in its entry GAL discharged. I have never, ever seen a court entry say the GAL is now discharged. They are discharged by order of the court when one of those factors listed in 2151281G is listed. As to know, when a GAL is appointed, they're appointed when there's an abuse, neglect, dependency. They're appointed when there's no parent. There's appointed when there's all the reasons for which a GAL would be appointed were no longer existed. The GAL, this court does not accept new evidence. The GAL does not need to report to this court. There is no reason why the GAL would continue to investigate. And in fact, when Judge Hendon issued her decision on December 1st, she closed all argument. I mean, everything was done. So what I meant to say is her December 1st entry terminated all prior orders. So the appointment by nature of that dispositional entry would have been no longer existed. So we have a GAL who was not appointed and filed a motion. She filed a motion that did not invoke any jurisdiction. She filed a motion for an emergency hearing, but then it was treated as an expedited hearing. But she didn't ask for anything more. She did not invoke the jurisdiction by asking to modify. She didn't invoke the jurisdiction by filing the dependency plaint. The court may have continuing jurisdiction under 2151.381F, but that somewhat depends on you and how you roll on the first one. And again, I would argue that that is not part of the dispositional finding, but she didn't file a dependency complaint. There was nothing in which to invoke the jurisdiction other than this so-called temporary or interim order, which wasn't even that. She asked that the spring visit with the parents not happen, period. Didn't ask for modification of the order, didn't ask for future, that the parents do something in which we could restart the visits, just spring visit, stop. Well, that's what Judge Hendon granted, and then she granted more. She says, okay, I'm going to spend all visits until this court makes a decision. Again, that doesn't make any sense to me. What's going to happen when you make a decision? Because there's nothing to invoke her jurisdiction to hear. What is she going to hear? So she has this order that one could say, if you read it one way, that, yeah, visits are suspended until this court makes an order. And the moment this court makes an order, that the visits resume.
Makes an order in this case.
Yes. Again, going back to the jurisdictional question, you have to invoke the jurisdiction. The court has the ability to hear. N. Ray Young pointed this out. It said, yeah, the court has the power of continuing jurisdiction, but the court can't just issue any dispositional hearing. You have to have something that invokes that jurisdiction. You have to have a mechanism that triggers it. Yeah, we'd all like to do what we think would be in the best interest of the kids, but we have to have jurisdiction in which to hear that. So let's step back a bit. As I've said, the parties have continued to rely on 2151.281 as the mechanism in which the court had continuing jurisdiction. To note, on the April 25th entry of the judge who denied the motion to set aside, she exercised emergency jurisdiction. She does not refer to continuing jurisdiction. She says she ruled on an expedited motion under emergency jurisdiction, but I have no understanding of what emergency jurisdiction she's doing this under. In this court, independency court, to issue any kind of temporary orders, you have to do so under Juvenile Rule B, which in essence says there is a pending matter. The only other time you can issue these type of interim orders is during a shelter care hearing, which is pursuant to a different statute, but has a pending complaint. There was nothing pending before the court. And what is pending before the court is a decision of who parties are. And that became a big issue in regards to the guardian ad litem and the invoking 2151.281, which in essence, the GAL and the children and the agency are parties under a dependency complaint. However, pursuant to Juvenile Rule 1C, the exceptions to that would be a parental allocation.
Attorney Thomas, I'll give you 30 seconds to wrap up, okay?
And so it would depend on what is filed, would depend on who's a party in this action, but 2151.281 clearly states that only the agency and the parties, which in this case would be the parents and legal custodians, could invoke the jurisdiction, and it has to be done so by a written motion and pursuant to Juvenile Rule 23 and 16. None of that was done. The legal custodians attempted to cure the defect of the GAL. Thank you very much.
Thank you. All right. So, Attorney Lee, you have 3 minutes.
Our appellee brief filed in April from page 26 through 29 outlines the procedural history in our response to this, but regarding the timing of the complaints, there's a couple of things we have to be clear. One is a request to dismiss self-executing. No one's touched that. It seems to be that everyone's like, well, it just goes poof in the night. It does not. It requires some sort of action on the part of everyone else. So even if we were to take that HMM is controlling here, as it relates to the January 17th entry that Judge Lips determined was a nullity, but this court subsequently said about a month later that it is okay to proceed. If we take all of that out and we assume that this is a nullity that would be covered by HMM, then that complaint that was erroneously captioned second amended complaint, which was technically a third, is a new standalone complaint, and it did a couple of things. There were some facts changed, but it changed the disposition that was being sought. So that is your new complaint. If, in fact, you proceed on the HMM standard, that this nullity stop time, that this is a new action.
You just mentioned something that we had a decision about a month after HMM. What was that decision?
Was it DG?
I don't know.
I believe it was DG, Your Honor.
I just wanted to clarify what you were referring to.
Correct.
Okay.
Then what happened was on, let me get the exact date. There was that, should have been it was third amended, but this court has previously ruled, I know I had another case on a sex offender issue, that caption doesn't matter. You've got to look at what the court actually does in the body of it. So this is a new factual and a new dispositional sought complaint. It is a brand new complaint. In fact, it stands as if we followed KM and dismissed and refiled. Then there is what is the fourth amended. That complaint was filed on March 13th.
So let me make sure I understand your argument. Are you saying because of the procedural posture at that juncture, that the Second Amendment complaint, which you're saying is technically the Third Amendment complaint, should be treated as a new complaint? Is that what I'm understanding your argument to be?
If this court is going to apply HMM and decide that the January 17th complaint that Judge Lips said was a nullity because there were no new facts in it, and which is what this court said in HMM, it doesn't extend the time. So if that is the case, the January 17th complaint ended. When we filed on February the 22nd, while it's captioned second amended, it should have been third amended if we're following the timeline in accordance with Judge Lips and this court's decision on the writ. That would stand as a new initial complaint. There were new facts in it, which is irrelevant if it's a new complaint, but it also is seeking permanent custody. Then on March 13th, and I know Judge Bergeron, you asked Ms. Bench this question, the fourth amended complaint was filed. We got the coroner's report. That's when the coroner's report came in that said AS died as a result of a homicide. That was the new facts that were entered that would change that second, technically third amended complaint.
So let me ask you this, just to make sure I understand your point. So let's just assume a complaint filed on January 1st, everybody blows past the 90-day deadline, no one says anything, so under KM, that's a problem. And then on...
Well, let me ask, is it a problem? Is it self-executing? If it blows...
The Supreme Court has said no implicit waiver. So let's assume there's no explicit waiver, which we said, okay, explicit waiver.
Sure.
So we get to June 1st, and then there's this dramatic new fact that you found. And so you file a Second Amendment complaint at that point that raises all these new facts.
Yes.
Under your view of the law, even though there's a violation for the 90-day period, is that effectively cured by the filing of the new complaint with, significantly new facts, regardless of when that happens?
I believe it would, because it's something new. Does it require, the question then becomes, does it require the trial court to say prior complaint dismissed? In this case, Judge Lips said it was a nullity. If it's a nullity, I think it's easy to construe that as a dismissal. It doesn't count. So we have maybe not the words, but we have the spirit that it doesn't. That is followed because this issue was also pending on a writ before this court. A week after this court ruled was when that second amended complaint came out with new facts, new disposition, and then on March 23rd, or March 13th, I apologize, that fourth amended, which would technically be an amended complaint if we treated it.
I think what you were saying earlier, what I had picked up on is because we had the matter before us and we ruled and we remanded it.
Yes, Your Honor.
And that remand would have been past the 90 days.
Yes, Your
And
Honor.
at that point didn't address the 90 days.
Correct.
That goes back to what I think you were saying in the beginning was because of the procedural posture at that juncture.
Correct.
That it should be treated as a new complaint.
Correct, Your Honor. Because as I was going back through this and I was listening to what you were asking, Ms. Benj, and listening to what other counsel was arguing, every complaint filed in this was within 90 days. The first complaint was filed, it had an older sibling that aged out. That led to the second complaint. On the 89th day, the second complaint was filed on January 17th that Judge Lips ruled as a nullity. As a nullity then, it's gone. We have nothing pending. But the matter is brought to this court for a decision on that. We proceed on that, but this new report or the new complaint is filed, a few new facts, but an amended disposition. The disposition is a key component as well. You're seeking permanent versus temporary custody. Then,
I'll give you 10 seconds to wrap up.
okay.
I have a quick question then.
Yes, Your
So
Honor.
you're asking us to overrule in re HMM?
Yes.
Okay, all right.
Yes.
That was quick.
Yes, I'm not a fan of the retroactive application of this. I believe that was a DG, and because we're looking at the retroactive application of this as if, and again, it goes back to void and voidable.
Well, I think when it's jurisdictional, and I think this goes to Pelly's point, is that you're dealing with a decision on jurisdiction. And so you can't say that there was jurisdiction before and now there's no longer jurisdiction. Really, when the Supreme Court spoke, they're basically saying there's just not jurisdiction. whether
Well,
it's
and
before or
we'll
after.
see what they say in KK, which is pending before the court now. I think it was argued in March. But again, what kind of can of worms does this open up to retroactively apply this to thousands of cases? So with that, but the motion for waiver was filed on April the 3rd. It was granted on April the 13th, 30 days after that new complaint was filed.
Thank you.
Appreciate it, and, this was, you all know.
Thank you. All righty. So I think that wraps it up. Now we have rebuttal from the appellees. Attorney Michael.
Thank you, Your Honors. May it please the court, the appellants keep talking about this retroactive application of KM. Again, KM is not new law. The 90-day requirement that KM discusses was the law at the beginning of this case, is the law now, and was the law way before this case. In INRE, HMM, and JAM, it is self-executing. This court stated that on the 90th day, that case expired, the time expired, the court lost jurisdiction, and it was completely self-executing.
Okay,
Now,
let me ask you this, ma'am. Even if it's, let's just assume that it is not self-executing. It's my understanding in this case that your clients filed a motion motion to dismiss, as well as a objection to the continuance. So I'm not sure why we're even talking about being self-executing.
I would agree, Your Honor. I would agree that my clients made all the proper steps to try and get the case dismissed, irregardless, within the 90-day period. There's this discussion about the writ, but what the appellants are failing to tell you is that the writ is actually against Judge Lips to make a decision. It wasn't a writ filed in this case for them to establish whether the 90-day requirement was active or whether the 90-day requirement should be followed. It was a writ because Judge Lips wasn't timely making a decision within the 90 days to execute whether the case should move forward or not. That is a drastic difference from saying that this court has decided and made a decision on the writ at that point.
Yeah, and I get your argument because as I understood the argument is because we remanded it for further proceedings and ignored the 90 days and kind of like treated it as if the trial court still had jurisdiction.
Correct, and I think that...
So I understand your argument in light of that.
Yeah, and I think that the issue becomes, this is the first chance that the parents have had to appeal this decision on the 90-day mark. These cases are not ripe for appeal until disposition has been completed, and disposition has just been completed. Additionally, dependency cases are a section of its own. So in the sense of curing the defect by filing a third amended complaint or whatever after the 90 days, that doesn't cure the defect. When these cases go back and they get dismissed, that essentially returns custody to the parents, and then the agency must then refile and show a whole new set of facts as to why the children have to be removed. This is not your general civil case. There are repercussions when you dismiss and refile. There are repercussions to the 90 days. It's not just as simple as filing an amended complaint when you have custody of someone's children.
So I'll give you 15 seconds to wrap up.
So as such, we're asking that this court dismiss this appeal as this case proceeded past the 90 days and in violation of the NREG-KM procedures.
Thank you.
Thank you.
Thank you, Your Honor, and I'll try to make it brief. I would like to quote what I was attempting to quote previously from N. Ray Young, which pretty much said, and this is Ohio Supreme Court, 1996 at 638, in essence, that the juvenile court have continuing jurisdiction does not mean that courts can grant dispositional orders indiscriminately. The court further went on to say that while we understand that the best interest of the child are paramount in any custody case and that we are to liberally interpret the statutes to provide for the care and protection of the child pursuant to 2151.01a, we cannot override unambiguous statutory language. Indeed, the juvenile courts derive their jurisdiction solely by grant from the General Assembly. Thus, they do not have inherent equitable jurisdiction to determine a child's best interest. And that's exactly what the court attempted to do here. The continuing jurisdiction was not invoked. And although she said she was exercising emergency jurisdiction, there is nothing to establish in which she issued that. There is no...
Your argument is there's no statutory provision that allows for that.
Correct. So she issued this order without any authority. Finally, the GAL and the other appellates have attempted to argue that because the GAL can participate in the appellate process, that she remains a party in the dependency process. Again, to hold that Juvenile Rule 1C makes an exception that they're not parties in an appellate court. But that, and again, there's nothing that says that that appointment was extended. There was no stay in this matter. This is a good order, and that's where we've left it. All matters before the juvenile court have been determined. We have a valid order, and the complaint, petition, motion, answer, counterclaim, whatever is filed will determine who the parties will be going forward, whether it's a dependency or a custody. Thank you very much.
Thank you. Thank you, everyone, for your arguments this morning. We will take the matter into submission and issue a timely decision. Thank you for all of your work on this case. State v. Klosterman. Good morning.
Good morning.
Thank you for your patience this morning.
Courtroom cleared out.
Now it'll feel like an echo chamber. Attorney Peters, whenever you're ready. Good morning.
Good morning, Your Honors.
Would you like reserve?
I'd like to reserve 4 minutes, please.
Right, thank you.
Your Honors, Ms. Surface, there's a lot of evidence in this case, but very little of it actually concerns the alleged crimes Mr. Klosterman was accused of committing against Ms. Strunk. When viewed without the distraction of the receivership and federal consent decree, this court will conclude that Mr. Klosterman's convictions are against the manifest weight of the evidence. The first offense that Mr. Klosterman was charged with was menacing by stalking. As this court is well aware, menacing by stalking requires that no person engage in a pattern of conduct that knowingly causes another to experience mental distress. In this case, the evidence showed that the relationship between Ms. Strunk and Mr. Klosterman began back in April of 2019 when she answered a Craigslist ad to do some secretarial work for him. Throughout the next year, she on and off performed some work for Mr. Klosterman. At the same time, she was also overlapping some of this time, she was also employed at D&D Advertising. However, this changed in March of 2020. At that time, Ms. Strunk entered into a lease agreement with Mr. Klosterman to rent one of his units. He also introduced her to Joe Lentini, who ran Tri-State Organization, which was a property management company. She was hired on by Tri-State to do some secretarial work for them. And during this time, also, Mr. Klosterman was put under the receivership order. And as part of the agreement with the receiver was that the Tri-State would manage the properties that were in the receivership. Now, at first, the testimony shows that Mr. Klosterman's involvement with the receivership was welcome and even encouraged. However, when he began to make complaints by how the receivership was running his properties, he was sent notice to no longer have contact with Ms. Strunk, and then by the receiver to no longer have contact with Ms. Strunk about the receivership, and then Mr. Lentini. During this time, the property that Ms. Strunk rented from Mr. Klosterman was not part of the receivership order. So there was no violation of the receivership order for Mr. Klosterman to collect rent or to be engaged in that. He also had an office located on the same street that Ms. Strunk's residence was, which was also not in the receivership. Fast forward, so through this time, he would have contact with her, and Ms. Strunk actually had no complaints and actually said that she didn't even have any inkling that there was anything wrong until September 16th of 2020. And that is when Mr. Klosterman, unbeknownst to her, contacted her former employer, D&D Advertising, and informed them that Ms. Klosterman was obtaining workers' compensation based on her employment with them.
Now, you argue Corpus Delicti. Do you want to go ahead and address that?
The Corpus Delicti is with the one of the violation of the protection order. Do you want me to jump to that instead of? Okay. So, as a result of events, Ms. Strunk did obtain a protection order against Mr. Klosterman. I believe it was the final violation of the protection order, which the argument was the Corpus Delicti rule, involves the argument that in November of 2020, Mr. Klosterman went to 2 properties on Steiner Avenue, which were in the receivership. So his presence on those properties is technically a violation of the receivership order, but it actually doesn't necessarily mean it's a violation of the protection order. However, when he sent
and so I think this gets to the point about the distinction between a confession and an admission to a fact, because that was the issue that I was struggling with as I was rereading this, and that the provision about the protective order says, only when the respondent knows or should know the protected person is likely to be there. So by him sending the email and saying like, hey, I went to these places, I don't view that as a confession to a crime because he didn't say, like, I did it, you know, I shot the person, I stole the goods or whatever, because the only way that that statement can result in criminal culpability is by connecting it with other facts. Is that fair?
But, okay, so one of the, I don't know if it's a fact or if you really consider it as a status. He's under a protection order. So, but by him saying he was at this property location, that's the only evidence they actually submit. So either it's the corpus.
Let me stop you there. Let me ask you this, ma'am. All right. So Mr. Klosterman knew where the prosecuting witness lived because he owned the property, right?
Correct, yes,
Right.
he knew where she lived.
Okay, he knew that there was a temporary protective order.
Yes,
where he
there was
couldn't-
evidence it was served,
He's
yes.
not to be within 500 feet of her or her residence, correct? Are you, right?
Well, if she is likely to be there. It's not a blanket prohibition against him being within 500 feet of her residence. If you read, if the term of it is when within 500 feet or a place that he is likely to expect her to be. Now,
Which might be her house.
which might be her house,
Right.
but at 2:45 on a work day, when she's employed at Tri-State organization, and Tri-State is not, so he would more likely expect her to be at Tri-State
Okay.
than actually at her residence.
Well, assume that she wasn't there. All right, then there's the letter to the city that you referred to, which Judge Bergeron referred to as an admission regarding his federal lawsuit against the city. Or then there's also testimony of service of the temporary protective order by the sheriff, and then the protection order was in evidence. So what you're inviting us to do is not consider that other evidence. Is that what you're saying? We only consider the admission that was made?
We're saying that the admission, that letter, the email that he actually sent to the city prosecutor, Ms. Martin.
You're asking us to look at that as in a vacuum and not consider any other circumstantial evidence that he violated that order?
But there's the violation of the order is because he violated the order. And the only way to know he violated the order is if you can place him in a place where where you put him in a location that's in violation of the
getting
order.
back to where I started, like say someone alerted him to the fact that he said, Ms. Strunk is at work right now, so you're okay to go there because you won't violate the protective order. So he says, okay. So he goes there, and then he does whatever he does, and he sends email like, I was there. That wouldn't, under those facts, maybe that's not a violation. So that gets back to my question of whether this email is a confession or whether it's simply an admission of a fact that can be used to impose criminal liability.
So this is with regard to the first issue that you raised under the assignment of error.
Correct.
So before you get to sort of manifest weight, as I understood your argument is that the confession, the email should not have been used because it's the sole evidence that a crime might have occurred.
Correct.
Okay?
Correct. So, I mean, again, the corpus delicti, you have to have.
And Judge Bergeron, what he's asking you is like, is it really the sole evidence that a crime might have occurred? In other words, is it a confession or is it an admission?
Well, the corpus delicti rule covers two things. You have the act and the agency of the act. What is the act in this case? It is the act of Mr. Klosterman going to a certain property. There's no other evidence in this case that establishes his presence at a property that was within 500 feet of her residence. Now, under the remaining assignment of error, the manifest weight, we talk about whether or not there was actual evidence. And it was still against the manifest weight because there wasn't proof that she was present or likely to be present because she was employed at the time. So the corpus delicti is the act, and the act in this case is him going to a certain location. And the only way that they know he was at a certain location is via his email to the prosecutor.
So what you're saying, the likely or should have known, which is really more of a mens rea thing, that doesn't go to the actus rea.
Right, it doesn't go to, I mean, that might negate another part of the offense, but it's the fact that he did a certain act. I don't think he has to, I don't think in order to satisfy the Corpus Delicti rule, he has to put in the email that, oh, hey, I'm under the protection order. I know I was in this property. I know she may have been present, but I went there anyway.
Well, it wasn't, the point of the email was that he was suing the city in a federal lawsuit. I don't know that it was to get himself in touch with this TPO, right? I mean, he was just informing the city, it's like, hey, guess what? I sued you. You left my building open. And then he happened to mention that he was at the building within 500 feet in the email.
Right, the email
His purpose wasn't to confess to a violation of the temporary protection order when he sent that email, right? I mean, I don't think it was.
He's fully admitting that he's there
But he
on
didn't
his
say
property.
he didn't say I'm here and I violated the TPO.
But I don't think the Corpus Delicti should be read that stringently to say, oh, hey, I am issuing a confession.
Well, but I think the thing that we're struggling with is if you read it more broadly, then suddenly any statement against interest is potentially subject to the Corpus Delicti rule. Because anytime you make a statement against interest, like you're potentially subjecting yourself to criminal liability. And if suddenly we say all those are out the window until you establish the facts of the crime independently, that's the concern, is how broadly does this rule sweep?
Well, respectfully, the state should be put to its paces. It is their obligation to prove beyond a reasonable doubt that a crime occurred and that the defendant committed it.
But does the Corpus Delicti require that?
The Corpus Delicti requires...
In other words, as I read it, it requires independent evidence. It could be just, it could be circumstantial, it could be direct, it could be indirect, but that there has to be something else that goes to what I'm going to call the actus rea.
And I would agree with your statement, Your Honor. And we would say that if someone had said, hey, I saw his truck driving away from that location, or he left a piece of mail with his name on it in one of the properties, that is corroborating.
Or she said, I came home that day and I did notice something weird.
Well,
and I didn't realize it was him, but I noticed something weird or something like that. Or
her testimony was that she had no idea he was at that property. She didn't know about it until, and it's confusing how she actually learned about it because the prosecutor doesn't quite admit that she sent the notice to Ms. Strunk, and Ms. Strunk said the prosecutor told her about it. But regardless, she made it a report, and that's the basis of the violation. So yeah, if they had looked for fingerprints on the doorknob because he touched the doorknob, and how else would he have known that the door was unlocked? I think that was one of his allegations
sort of
in the...
more direct, but I mean, it seems as if there has to be something. It could be the most, circumstantial of anything evidence that there must be something else. Otherwise, that statement of against interest does come in.
Correct. If there is something else.
If there's something out there.
Yes, something to corroborate the act. And in this case, there is nothing to corroborate the act independent of Mr. Klosterman's statements. So on that basis, for the violation of the protection order, which is the third case, we would request that of the Corpus Delicti, and even if you're not willing to, or think you're expanding the Corpus Delicti too far, we would still argue it's against the manifest weight, because again, there has to be some evidence that he was aware that she was likely to be present at that location, that the location, so his
Your
Steiner...
manifest weight argument goes to that element.
Right.
But your Corpus Delicti goes to the actus reus.
To the actus reus,
Yes,
yes, correct.
I'll give you 10 seconds.
Okay.
You're a little bit beyond, but that's
okay. Well,
you want to wrap up?
Yeah, I'll wrap up, and unless the court has any further questions, we would submit that Mr. Klosterman's convictions are against the manifest weight. Thank you.
Thank you. Good morning.
Good morning. May it please the court. Ms. Peters, thank you very much. I actually would like to start by addressing the Corpus Delicti issue. I felt like that probably was where the court wanted to hear the most, and I heard some of your questions, so with due respect, I'm going to kind of just start with some of the things that you've already asked.
Please do.
First of all, Judge Winkler, to your issue with regard to where what the protection order itself actually required, I'd also like to add that in reviewing the protection order itself, item 1 of the protection order requires that Mr. Klosterman not enter into any properties that are owned or managed by a business that employs Ms. Strunk. And I think the overriding issue here is that this whole relationship went down as a result of the business
I want to make sure I
relationship.
understand your argument, okay?
Certainly.
Are you saying that the protection order was broader than as the appellant was articulating it, that it did not necessarily require for him to have possibly known that she would be at the location?
Absolutely, because there are different segments in that protection order. Segment number, I believe, 4 is stay away from the petitioner in places where you know or believe that she is likely to be. Also, another fact that was in evidence is the business itself, the actual business office, Tri-State Organization, is 2 blocks from her home, which also is in the protected 500-foot area. This was in the middle of the afternoon on a work day. He knew or was likely to know that she was either going to be at home, which was, I believe, 39 feet was the distance from property line to property line.
And I think there was testimony of all of those measures.
Within another block, exactly. We brought Cages in to testify with regard to those things. In addition, however, he absolutely knew without question that the properties that he was entering onto were in the receivership, which currently employed Angel Strunk. So the property that he was entering into, there also was a very good possibility, and Angel Strunk testified to this, that she would be doing some sort of inventory there or managing on site at one of those properties. So there's a whole lot.
Just going back to the Corpus Delicti rule, like,
Yes.
I think part of the purpose for it is to ensure that someone doesn't get convicted of a crime that didn't occur. And I think that's really the thrust of the defense argument is nobody saw this guy there. You know, the victim certainly was not aware of his presence. And the only thing connecting him to that is his statement.
Exactly, except that there are other things about that. So what we do is we start, I believe, that the starting point, Your Honor, is to analyze what the purpose of the confession or admission rule is. And we start with, and you've stated it absolutely correctly, the rule is designed to prevent the conviction of the coerced or mentally unstable for fictitious crimes. And that comes from the 64 Ohio State Law Journal at 817. Also citing the Ohio Supreme Court in State v. Edwards at 49 Ohio State 2nd, I think this is very important. The doctrine was born out of consideration of certain cases of homicide where the state failed to prove that there was a death, the victim actually being alive, but a confession itself was coerced in some way. So we have to have some coercive nature.
But it's also been used where there has been a death, but no evidence of any homicide. So while I understand what you're saying, the same thing with the first citation, obviously, we would want to protect people that are mentally stable in addition to those mentally infirm.
We certainly do. We certainly do. So the appellant argued that the state bears the burden of proving Corpus Delicti beyond a reasonable doubt, but we don't. In fact, I think as you pointed out, Your Honor,
yeah, I think that
it's just a scintilla of evidence that's necessary.
Just those smattering of evidence that there was a crime that occurred and that statement is going to come in.
And the question then becomes, do we have to have evidence that he was there on the property, or do we have to have evidence that corroborates whether or not his statement was uncoerced in some way? Whether
I would love for you to cite a case for that it requires coercion in order for the statement not to come in.
I'd ask the court to review State v. Edwards at 49 Ohio State 2nd, 31. the Ohio Supreme Court in that case says, in light of the revolution of criminal law beginning in the 1960s and the vast number of procedural safeguards protecting the due process rights of criminal defendants, the rule is no longer supported by practical or social policy considerations, and the Ohio Supreme Court sees little reason to apply the rule with a dogmatic vengeance. So what I believe is, in this case...
And are you citing majority there?
I am, Your Honor. That's from the opinion itself. Going back to Judge Winkler's statement early on about whether you should take these facts as if they occurred in a vacuum, I think the answer is absolutely not. This case did not occur in a vacuum. By the time November 2nd came around, not only was Mr. Klosterman charged with the stalking charge, the initial stalking charge, but also was charged with one violation of a protection order. So there can be no argument whatsoever that he wasn't already aware that there were protections in place. No argument whatsoever. Mr. Klosterman, I believe...
That all goes to mens rea.
It does, indeed. And of course, the mens rea for violating a protection order is recklessly, not knowingly, which I think is another important factor here. So the evidence at that point is Jacqueline Martin, and by the way, the prosecutor, I don't believe that the prosecutor ever said anything about contacting, because that would have been me, contacting the victim. In fact, I believe that what appellant meant was Jacqueline Martin, who was with the solicitor's office as well, who was involved on the civil side. And she may or may not have been the person who contacted Angel Strunk, but I don't believe that that's relevant one way or the other. But the evidence that was before the court at that time, before the jury at that time, was his involvement with these properties. So does it make it credible based on all of that evidence that he did indeed enter into the property at that time?
But is it about credibility, or is it about whether there's external evidence outside of the statement that a crime had occurred?
Judge, I think that it all comes down to credibility of the statement. I think that that's the whole purpose of the Corpus Delicti rule. Is this a credible and competent statement?
Can you cite to a case that there was no outside evidence, but because of the credibility of the statement, that was enough to overcome Corpus Delicti?
I believe, Your Honor, that goes back to State v. Edwards in the 1970s, the Ohio Supreme Court. That's still good law.
But are you saying that the Supreme Court essentially kind of eradicated the doctrine of Corpus Delicti?
I believe that while not eradicated, I believe it substantially emasculated it, eviscerated it. I believe that the doctrine itself, the purpose of that doctrine, and I think we have to start there. What's the purpose of the doctrine? The purpose of the doctrine is designed to prevent the conviction of the coerced or mentally unstable for fictitious crimes,
So
as you've indicated.
Yeah, I mean, so
your
your perspective of Corpus Delicti today is it's limited to that circumstance.
I do believe that. I believe that as long as there is competent, credible evidence that the statement is not coerced, then I believe that the statement itself stands. And in addition to that, I go back to my argument, which I submitted in my brief, that this is not a confession. This is not any statement by a man who believed that he was engaged in a wrongdoing. And I would ask the court, I believe in my brief and maybe also in the appellant's State v. Miranda.
Under what definition does it require that?
Was cited.
Corpus Delicti.
That definition is in State v. Miranda, actually cites the difference between a confession and an admission, I believe.
Right, but we're talking about under Corpus Delicti. I mean, it's interesting because we're using these terms, and interestingly enough, the term that governs Corpus Delicti in defining confession has the term admission in it, and yet we're distinguishing a confession from admission. So, these are obviously terms of art that are limited to the application for Corpus Delicti.
True. I think that when we talk about confession itself, what we're talking about initially, and I think over time, historically, we've ebbed and flowed through case law on this, but confession is what you say to law enforcement. That's where we start from, right?
Well, that's for general confession. I mean, the case law defines confession for Corpus Delicti as an admission of a criminal act.
Exactly.
That's it.
An admission of a criminal act. So State v. Miranda, I believe, was the rape of a small child, and the statement that was asked to come in was his statement to another family member where he said, I wouldn't have done it if she didn't look so much like your mother. Right there, it's not law enforcement, but there's a statement in there of admitting that he has that he has engaged in a criminal act
Correct.
itself.
And then Corpus Delicti says that confession must serve as secondary evidence.
Correct.
So there has to be some other evidence.
And in that case, that's a confession. What we have in Miranda is a confession. What we have in Klosterman is never a confession. In fact, he acted as if there was nothing wrong with him being where he was supposed to be, that by all rights and responsibilities.
So you're saying the statement has to
he was-
acknowledge that there was a criminal act, that the actor believes that they engaged in a criminal act.
I believe in order for it to be a confession and subject to Corpus Delicti, it does have to. I believe that it has to.
Okay, and if you can cite a case to support
I
that.
believe that I cited one in my brief, Your Honor.
Okay.
So I would just submit on that, because I believe that in my brief, I specifically went through the difference between confession and admission. I would like to submit on that with regard to that specific argument and definition. With regard to manifest weight of the evidence, and of course, Corpus Delicti is judged by the same standard as manifest weight of the evidence, where the court sits as 13th juror, reviews all of the evidence, the totality of the circumstances. With regard to all three of these charges, I believe that the state met its burden and produced a sufficient weight of evidence in order to support those convictions. Does the court have any other questions with regard to either manifest weight or Corpus Delicti?
So on manifest weight, at the onset of your argument, you were saying that the protection order was broader and didn't necessarily require the knowledge that Strunk would be, or should have known that Strunk would be likely to be on the property.
No, he absolutely does not have to. And in fact, the protection order itself never says no or should have known. It says wherever those persons may be found or any place he knows or should know, they are likely to be. You would know or should know that somebody's likely to be either at home or at work during the middle of the day, especially given his particularized relationship with Angel Strunk, where he had previously employed her and had been engaged with her throughout all portions of the receivership coming into place and going on from there.
Thank you.
Thank you.
Judge Ayers, I would like to pick up on a point that you raised about the admission versus confession. And actually, the cases cited by the state don't actually involve the Corpus Delicti rule. The State versus Clements, it was about what the statement that the prosecutor was making in closing arguments. And then the Salmon case was about the jury instructions. So the cases that they actually used to say, well, a confession is different from an admission is not being raised in the Corpus Delicti.
It's not in the context
Yes.
of what a confession is with regard to
Correct.
Corpus Delicti.
So when Corpus Delicti talks about admission, I would think that even if you just take it as an admission and not a confession.
Well, so I guess the question is, in your view, like, let's say the statement, let's say there's 5 elements to the crime. The statement doesn't say anything about the crime. The statement simply admits to one element of the 5. Does that trigger the Corpus Delicti rule in terms of, like, well, we can't let that statement in until we have independent corroborating evidence?
If it goes to the act, yes.
Okay.
And in this case also, Ms. Surface referenced the fact that the tri-state office was just 2 blocks from Ms. Strunk's residence, but there's no testimony about the distance. I mean, it's 2 blocks, but we don't know, is it 2 huge city blocks, 2 small blocks? We just know, she just said 2 blocks. So we don't actually know the distance between there, so whether or not, because the the map that has the distances on it that was submitted into evidence doesn't actually pinpoint the tri-state office. And as far as the place of, that he was not permitted to enter a place of an employment, again, those are rental properties. Those are not her places of employment. Her place of employment was this tri-state office. She may have to go visit other locations, but I wouldn't call those her places of employment. And she said, yes, around that time, she was doing inventory at certain houses, but she could have been doing inventory at a house that took her well beyond the 500 feet. So we don't know that. She couldn't pinpoint it. No one knew exactly where she was, except she wasn't at the Steiner Avenue, and she didn't see Mr. Klosterman there. I would like to briefly touch on, if I may, the menacing charge, because the menacing charge, there has to be a pattern of conduct. The first one was his report that is really relied on is him reporting her workers' comp claim to her former employer. And then the second one was this, where he was outside a different property, which was his office, which was on Delhi, and she went out at the same time. He didn't make any contact with her, he didn't talk to her, he didn't do anything, but she alleges that he zoomed past her in his big pickup truck and carrying a U-Haul, and that he was doing these maneuvers behind her. It's just not credible, Your Honors. I would like, I mean, if you look at the big, you can see the picture, the still photo. Yes, he has a truck, there's a truck, and there's a U-Haul. And again, but also whether or not he was truly following her, she acknowledges also that this was the only route to I-71 North, and that he didn't follow her afterwards. And then the mental distress. The first incident, she didn't testify it caused her mental distress. In fact, she threatened Mr. Klosterman. It's going to get worse for you. So what does she do? She reports him for following her and then makes this allegation. So you really only have the two incidents, because up to that point, her testimony was she had no inkling that there was any problem. She was not in any mental distress by any actions that Mr. Klosterman did prior to September 16th. So and when you're talking about the mental distress, even if you take his actions towards what he did to D&D, the statute says about mental distress can be, for the person, can be considered if it's aimed at an organization, association, or employer. But she was no longer employed by D&D. So his actions of reporting, and she admitted that she was receiving workers' comp. D&D didn't know it. Mr. Klosterman just informed him of it. So we would argue that that conviction is against the manifest weight.
Thank you both.
Unless there's any further questions, we'd submit.
Thank you both for your arguments this morning. We will take the matter into submission and issue a timely decision. Have a wonderful afternoon, and that concludes our arguments for this morning.